Right. The first thing I'll just mention is you'll have to bear with me. My voice is not the best. I'm not the picture of health right at the moment. But even if you decide to tune out from Part 4A discussion, because I'm about to descend into some of the detail of the cases, you might be able to run a book on exactly how long my voice actually lasts for to keep yourself interested. Anyway, the way in which I've structured this presentation is to really focus on Part 4A, the income tax anti-avoidance provision. I have, at the end of the presentation, my final slide for today, sort of tipped my hat to the fact that there are general anti-avoidance provisions that operate in other contexts, indirect tax being an obvious example. I make no mention of the fringe benefits tax equivalent, but certainly they are out there, and I do hope to give you a bit of a comparison about some of the provisions, both the similarities and also some of the differences. But the reason for the focus on Part 4A is pretty obvious, and that is that the Federal Court and the full Federal Court have been very, very busy in the last 18 months. So busy, in fact, that I'm not even going to pretend to cover all of the cases. In fact, when Citigroup was handed down, I think the week before last, I just felt tired and decided that there was no way I was going to get my head around the cross-border arbitrage between Australia and Hong Kong for the purposes of today's discussion. So unfortunately, Citigroup's not amongst the cases that I'm going to talk about. But what I have done is selected a few of the cases which I think give you a bit of an overview, sort of selected highlights, if you like, of where it is that the jurisprudence on Part 4A is going in this sort of post-Hart world. Hart, of course, was the income splitting case that was decided in 2004 by the High Court. And if you suggested at the time that there was really any sort of single ratio emerging from the three judgments, because there were three judgments, one from Justice Callanan, one from the Chief Justice Gleeson, and I think it was McHugh, and then there was Justices Gummow and Hayne. When you looked at those three judgments, there were some subtle differences that actually emerged from each of them in respect of issues such as how to determine dominant purpose, what the meaning of the scheme was, and the like. And now with this sort of recent spate of cases, what we're beginning to see is that there's a bit of an orthodoxy that's emerging. And what I'm hoping to do is to actually describe to you what that orthodoxy is and what it actually means for running cases on Part 4A. And the other observation I'm hoping to make is actually that there are a couple of rumblings of discontent about dominant purpose and whether or not the approach that has emerged is necessarily the right one. But I won't spoil the surprise. We'll get there in time. Prior to Hart's case, there was a prevailing view that the determination of scheme was very, very important, and that if the scheme was determined too narrowly, it was possible for the Commissioner to more or less disregard aspects of the commercial advantages with schemes. So there was a debate playing itself out about wide versus narrow schemes and their significance and the Commissioner's ability to really just focus on one step. And as Bill mentioned, that had been based on a few words in Peabody's case about standing on its own feet without being robbed of all practical meaning. And Hart's case effectively said that case, Peabody has been sort of relied upon as deciding more than it actually did. And all that's required really here, well, there was a bit of a divergence, but in one of the judgments, all that was required was some sort of connection between the scheme and the tax benefit. In other of the judgments, it wasn't apparent that any limitation as to what could be identified as the scheme really was left. The recent cases seem to have picked up their cues from Hart's case, and that sort of you really can't rely on the scheme as a limiting factor with respect to Part 4A. There have been a few exceptions, and I really do think that those few exceptions, which I'll talk about, do begin to demonstrate the fact that there's really not that much left in respect of scheme to rely on anymore. The Ashwick case was the Foster's Group bad debt and intragroup lending case. So what the Commissioner had done had more or less assessed a whole series of entities in the Foster's Group, denying deductions either for the write-off of bad debts or alternatively for interest costs on intragroup loans. one of the challenges mounted by the taxpayers in Ashwick was that the Commissioner had, in fact, determined that the scheme that the Commissioner had determined had been too narrowly defined. One of their challenges to scheme was that the way in which the Commissioner had defined the scheme started, I think, in November 1989, and that there'd actually been anterior activity to that point in time, other lending within the group, things that should have been taken into account with respect to whether or not those intra-group transactions were sort of economically necessary as part of the funding. Another challenge to the identification of the scheme also emerged out of the fact that while the Commissioner had denied the deduction for the interest expenses, he'd simultaneously left intact the assessment of assessable income on the other side of those lending transactions within the group. And the complaint was that that was an impermissible sort of definition of the scheme where basically there was no symmetry between what was done. At the full federal court level, they found that a scheme did in fact exist. At first instance, this case was a bit anomalous because the first instance judge, Justice Ryan, decided that there wasn't a scheme. Full federal court level, that decision was overturned, and what was basically said, and it was by Justice Edmonds, who of course is a sort of tax specialist judge in the New South Wales jurisdiction, with whom the other two judges agreed, was that while some of those other features may in fact be relevant, so the anterior activities, the lending that occurred before November 1989, it might be relevant to issues such as dominant purpose, wasn't relevant to saying that the scheme had been too narrowly defined. And similarly, the assessment of the assessable income, the interest coming in on the other side of the transaction, that might be something that gets taken into account when the Commissioner makes a compensating adjustment, because he has the power after Part 4A is applied to more or less annihilate the entire transaction and restore people to the position that they would have been in had the scheme never been entered into. But that's something that doesn't get done until the initial cancellation of the tax benefit is complete. So there was some acknowledgement that the things that have been identified may in fact be relevant, but they didn't limit the scheme in the case. The taxpayers in British and American tobacco tried a slightly different approach. Rather than trying to argue that the scheme that had been identified was too narrow or couldn't stand in the way in which it had been identified, what they actually tried to suggest was that the scheme should have been more narrowly identified. And the reason for that was the attempt to get the advantage of an exclusion from the definition of tax benefit. You're probably aware that there are a couple of exclusions from tax benefit where more or less the tax benefit is attributable to a choice or election or agreement or decision that's expressly provided for in the Tax Act. And there's another one, which is the one in this context, which I think it's the consolidation and specific rollover, and it has to be solely attributable to that particular choice. That the tax benefit has to be solely attributable to that particular election or choice. What happened in British and American tobacco was that BAT was pursuing a global merger with Rothmans. And as part of that global merger in Australia, the ACCC had expressed concerns about the fact that it was going to leave very little competition in the marketplace. So there was a decision that there would need to be a divestment of some of the tobacco brands owned by BAT to allow the merger to proceed with approval. The decision was to sell these particular tobacco brands to Imperial, but the way in which the transaction was established, and the facts indicate this, that there was a lot of concern internally that BAT hadn't sort of initiated discussions with Imperial directly because they wanted to make use of some capital losses that were available in Rothmans Asia. So the way in which the transaction was implemented basically interposed Rothmans in the series of transactions, with BAT getting a rollover relief on its capital gains at the first sort of transfer of the shares or the transfer of the assets to Rothmans prior to Rothmans then transferring to Imperial. And the argument here was that the entire scheme was just solely that particular choice to apply the rollover. And the court just rejected it out of hand. There is a little bit of analysis, but more or less I think that this is just an instinctive response to the fact that there are a few steps there which include the interposition of Rothmans and the fact that Rothmans then subsequently transferred the brands to Imperial. So the antecedent and the prior and the subsequent steps were part of the scheme and weren't merely context that surrounded the choice of that particular scheme. I haven't included it, but Futurus was also an example where scheme was argued. It was a number of different arguments were made. Each was rejected pretty much out of hand, reasonably rapidly by the court. The tax benefit, of course, is sort of central to the operation of Part 4A, and certainly Hart's case didn't diminish that, and now the sort of next lot of cases still very much emphasising the importance of the identification of the tax benefit, and are now indicating that this is one of the sort of core areas of preparation for cases that have emerged, because it's very deeply interrelated to how the dominant purpose is going to be ascertained. Now, there's of course the fact that the tax benefit, as it's defined in Part 4A, is reasonably limited. There is of course a Treasury discussion paper out at the moment which has sort of re-enlivened the debate about whether or not there should be an extension in the definition of tax benefit. This, of course, is a debate that's happened before, and I think there was, in fact, a government announcement that they were going to do this just in the wake of the Ralph Review in 1999, but nothing actually happened at that time. So for present purposes, and certainly the provision that all these cases deal with, is 177C of the 1936 Income Tax Assessment Act. And that tax benefit under that provision is limited to an amount that's effectively been excluded from assessable income, an amount that's been allowed as a deduction, or alternatively an entitlement to capital losses or foreign income tax offsets. I've noticed in my paper that I've written foreign tax credits. That, of course, has changed its name recently, but I'm obviously stuck in the past, as a lot of barristers probably are, given that we look backwards. So accept my apologies for that error. This is where the counterfactual is absolutely critical, and it's really the emerging area of discussion in the identification of tax benefits for the purposes of Part 4A. This sort of reasonable hypothesis or prediction about what would have happened in the alternative. Now, I've tended to use the expression alternative postulate to describe the counterfactual. It is in fact the same thing. So any reference to alternative postulate in my slide or paper can be read as counterfactual or alternative hypothesis, as the case may be. The Trowell Brothers case is the first in a sequence of cases that deal with the tax benefit, or the recent cases that deal with tax benefit. What it dealt with was, I think, Mark and Alan Trowell. They were employed by the taxpayer, and as part of their employment contract, there was an agreement that certain amounts would be contributed to a superannuation fund on their behalf. And at the point in time where, and this of course is dealing with the old superannuation legislation, the reasonable age-based limits were introduced, which limited the amount of the deduction you could get for the superannuation contributions made for your employees. So in order to circumvent the introduction of those age-based limits, there was an oral agreement to vary the employment contracts, and instead of contributing the amounts to a superannuation fund, the contributions were made to an employee welfare fund that they'd just established. I think $210,000 had been contributed in each of the years in dispute, in 97 and 98, and the taxpayer had claimed deductions for those full amounts of the contributions. The question in this case, insofar as the identification of the tax benefit went, was what could be postulated as the relevant counterfactual in the circumstances, and whether or not the amount of the tax benefit that had been identified was right. What actually happened in the case was, initially the taxpayers had been successful before the AAT, and then at first instance before the federal court, that had been overturned and it was going to be remitted back to the AAT for determination. This was an appeal against the trial judge's provision, and there was, in respect of this question about the identification of the tax benefit, a dispute had emerged about who was actually responsible for establishing what the counterfactual actually was. And the the majority made the following observation. This is Justices Dowsett and Gordon. The taxpayer submitted that the Commissioner, not the taxpayer, had the burden of identifying the alternative postulate, and that only the Commissioner had established an alternative postulate, that once the Commissioner had established the alternative postulate, did the burden shift to the taxpayer to show that the Commissioner's alternative postulate was only a possibility, not a prediction sufficiently reliable for it to be regarded as reasonable. We reject that submission. It is the taxpayer who bears the onus to establish that there is no tax benefit in connection with a scheme. How the taxpayer does that is a matter for it. It may, for example, as Justice Sackville said in Lenzo, lead evidence that the taxpayer would have undertaken a particular activity or adopted a particular course in lieu of the scheme. It is also conceivable that a taxpayer may not lead positive evidence of an alternative postulate because, for example, the result of any objective inquiry of the alternative postulate is inevitable. In the end, the court will decide what would have been done or might reasonably be expected to have been done in lieu of the scheme having regard to all the evidence that is led, and then it goes on. So that's a fairly clear sort of indication that it's really the taxpayer's responsibility. That said, when you read through the rest of the cases, it does seem that the Commissioner in most instances has identified some form of alternative postulate, and often it's quite difficult to ascertain where the onus lies when what the court is doing is basically attacking the alternative postulates put forward by the Commissioner. But I think this is probably the determinative, or the sort of the principal sort of approach is the taxpayer actually has to lead evidence as to their alternative postulate and lead evidence that would counteract or contradict anything that the Commissioner has suggested might otherwise have occurred. Now, there were a few other aspects of the tax benefit that were dealt with in Trail Brothers. One is that the tax benefit the alternative postulate doesn't have to be predicated on exactly the same type of tax benefit. So it doesn't need to be, in this case, a deduction under the same provision as was required under the scheme. So it's not necessary to identify that particular provision of the Act as the source of the alternative postulate. And also, there was also an indication in this case that when you're identifying the alternative postulate can comprise some of the steps that form part of the scheme. That's something I'm going to return to because it was also something that seemed to come up in AXA in relation to whether or not you had to disregard the entirety of the scheme, and there'd been some indication in a prior case of Lenzo that that might be necessary, or whether some aspects of the scheme, some steps of the scheme could remain intact in relation to the alternative postulate. Now, for tourists, and you'll forgive me if I don't go into all the detail of this particular case, but more or less what this case dealt with were a series of transactions that took place in advance of the taxpayer having a float of its building products division. Now, the reason for these transactions were that its building products division assets were held by different taxpayers within the group. So it was necessary to have a transfer effectively of shares in one of the subsidiaries to another subsidiary, a further disposition of the shares in that other subsidiary prior to the public float taking place. Now, the tax benefit in this particular transaction related to the CGT that the taxpayer for tourists had borne on its sale of shares. And what the Commissioner had done was increase the amount of assessable income to the taxpayer on the basis that certain cost-based uplifts that occurred as a result of the pre-disposal restructure were to be ignored. And those cost-based uplifts for the shares arose, I think, out of a market value substitution rule and also out of the application of a specific anti-avoidance rule relating to value shifting. So what had happened, you had the pre-disposal restructure, the cost base of the shares had increased, and then on the subsequent disposal, a reasonably small capital gain had been realised by the taxpayer, and the Commissioner said, no, that should actually be an $83 million capital gain that's been realised. Now, what happened in this case is twofold. Firstly, the Commissioner had put forward a couple of alternative postulates, but principally, what the taxpayer had done in order to both reject those alternative postulates and also put forward its own proposition that in any event it would have had a public float of the building products division, and it would have been structured in a different way where basically the ultimate disposal would have occurred in a different taxpayer, therefore indicating that the taxpayer in this particular scenario wouldn't reasonably have been expected to have made the assessable income. The way in which they did that was to lead expert evidence. There wasn't actually any indication that there was evidence of directors or staff of the taxpayer entity. There was just this expert, or a series of experts, but the principal one being a specialist in corporate finance from Deloitte, who sat down and identified, based on the sort of accounts and the corporate structure, what would have otherwise happened. And in his expert report, he had regard to implementation costs, the attractiveness of the financial structure of the listed company for the purposes of a public float, including the book value of its equity and assets, the impact of the forecast profitability and consequences in terms of existing contracts and the amount of disruption. So the expert basically indicated that, having regard to all of those matters, it was reasonable to assume that a public float would have occurred in any event, and it would have occurred by reference to another entity. Now, that expert's evidence was accepted. There really wasn't terribly much of a challenge to it, and it does indicate that an expert can be used to establish what the alternative postulate would have been, and that an expert can be used very, very effectively to do that, because this is a case where there was no tax benefit and it really wasn't necessary to take the case any further. Excuse me. In terms of the Commissioner's alternative postulates, they weren't really explained in any great depth, but one of the things that I thought was quite interesting about them, because there were two presumed counterfactuals on behalf of the Commissioner, was that one of them seems to have actually been rejected because it would have resulted in too much tax. And the judge, in this case Justice Basanko, basically said, I don't think that it can be concluded that the corporate group would have exposed itself to capital gains worth $235 million in relation to a float of the building product division worth $250 million. Now, I actually think that that's probably a fairly reasonable conclusion. But given that Part 4A is ultimately predicated on finding another way of doing the transaction that does involve more tax, or else you wouldn't have a tax benefit, it's interesting that there probably seems to be some sort of natural cap on how much tax it would be reasonable to expect taxpayers to expose themselves to. Now, in relation, a bit of trepidation talking about AXA in light of Greg's involvement in the case, but in any event, AXA clarified this debate about whether or not you needed to ignore the entirety of the scheme in formulating the counterfactual, or whether it could involve some steps. Broadly speaking, AXA Pacific Holdings, AXA, owned shares in AXA Health, which operated the HBA health insurance business, and it disposed of those shares to a subsidiary of Macquarie Bank called Macquarie Health Funding. And the way in which that transaction was structured, the disposal was part for cash and partly for the issue of, I think, convertible preference shares from another entity, perhaps a holding company of the Macquarie Health Funding entity, the parent of Macquarie Health Funding. And AXA claimed partial script-for-script rollover relief in respect of that transaction. And the ATO, this is setting aside all the questions about arm's length dealing and the like, what the ATO had done in respect of Part 4A was that they had disallowed the availability of that rollover relief in respect of the disposal of the shares in AXA Health. And what happened was there'd been a notice of contention filed by the taxpayers trying to sort of dispute the Commissioner's counterfactual. And the Commissioner had proposed as a counterfactual a direct transfer of Macquarie Health Funding, I think, for cash. And the notice of contention more or less said, no, that actually contains a few steps that form part of the scheme, because there wouldn't have been a direct transfer to Macquarie Health Funding because that was a special purpose subsidiary that was incorporated specifically because of the transaction that was taking place. We would never have done that. So you have to ignore it and it can't form part of the alternative postulate. And the reason for that notice of contention is the following statement in Lenzo. For reasons I have explained, in assessing the counterfactual, section 177(1)(b requires the entirety of the scheme to be ignored. The statutory mandate is not fulfilled if only part of the scheme is ignored and the rest is assumed to continue intact. That would seem fairly unambiguous, but of course that there was always Trail Brothers saying that certain integers from the scheme could also form part of the alternative postulate. When the court rejected the notice of contention, basically what they said was, oh no, you have to ignore the whole of the scheme when you're applying Part 4A, but in formulating, that's only half the question that's being posed. In formulating your alternative postulate, you can in fact restore some integers of the scheme. So it is permissible to have some integers within the alternative postulate. And yes, the joint judgment of the full federal court in AXA at paragraph 133, actually he says expressly, it is contrary to the express words of section 177C, its context and its purpose to exclude particular integers from a prediction about what would happen or might reasonably be expected to happen. Put another way, absent particular integers, the inquiry would not be an objective inquiry as required by 177C, but a prediction of what would happen or might have happened, having regard to only a subset of the integers available to the taxpayer, and then they cite Trail Brothers. That said, despite the failure of the particular notice of contention, the Commissioner wasn't successful in AXA for a number of reasons, and one of the areas in respect of which the Commissioner wasn't successful was his attack on the way in which AXA did actually establish what its version of the alternative postulate would have been. They'd led evidence given by an executive director of Macquarie Bank about what would have happened had this scheme not actually occurred. And the accusation was made that that evidence was speculative and without any sort of foundation. And the court, when it had regard to those arguments, more or less said, well, actually, you can speculate. Well, you can speculate. No, the evidence is acceptable provided that it actually has factual circumstances on which it relies and which support what is said in that evidence about what we would have done or would have done but for this scheme being available to us. And I think it's consistent with earlier authority that that is an acceptable way to do things, but it does really highlight the difficulty of proving a course of action that never occurred. So I think the lesson to be learnt from AXA insofar as the alternative postulate goes is that when you formulate your evidence, it is necessary to actually identify the things in the factual matrix that do support that particular course of action, I guess, or course of action that wasn't taken. So if you're advising at front end, one of the things that you probably would be suggesting to your clients is that they do have regard to what other alternatives do in fact exist in the circumstances. Now, there was actually a little bit of a sort of postscript to the identification of the tax benefit in AXA, and that is that Justices Edmonds and Gordon, both of whom were tax practitioners or tax specialists before joining the judiciary, did actually observe that there was another alternative postulate that might have been available on the facts. And they say at paragraph 147, the finding that it might reasonably be expected that the alternative postulate was a direct sale to MBF is a further example of the difficulties which now arise in litigation concerning Part 4A, where the focus is on the scheme and the alternative postulate identified by the parties. Of course, this is a direct result of the adversarial process. The problem is that it does run the risk of creating considerable artificiality, often divorced from commercial reality. And suffice to say, the Commissioners' Council jumped on that, and in their special leave application to the High Court, which actually was unsuccessful, they had argued that the recent line of authority, and certainly the decision in AXA at the full federal court level, had given too much emphasis to the tax benefit, and tax benefit was just meant to be a gateway, and it's not meant to be this major forensic exercise. As I said, the special leave application was unsuccessful. The court just basically said this is a factual finding in the circumstances. But it is some indication that increasingly the way in which you decide to run your case may in fact, well, in a Part 4A context, and how you identify the alternative postulate may in fact decide what actually happens in the end. And just on that point, I will mention Citigroup. I've heard it indicated or suggested by some that if Citigroup had run an alternative postulate in their case, rather than sort of having a do-nothing alternative, if they'd actually said we needed $50 million worth of funding, which seemed to have come out of the facts discussed at first instance, and this is the way that we would have done it, that the outcome may in fact have been different, and it might have diverted attention from the fact that the transaction was pre-tax negative if you had regard to the payment of Hong Kong tax. Anyway, I should have avoided Citigroup. Just by way of aside, Ashwick has a really great summary of the state of the law on alternative postulates so far. I don't propose to read it all. It is in the paper and it takes up over 2 pages, but it really is a snapshot of exactly where we are in respect of the alternative postulate at the moment. Nosa Holdings is another case that dealt with the exclusion from the tax benefit provisions that I was talking about before in respect of British American tobacco. For some time there's been an argument kicking around that the choice to consolidate might in fact be a consideration that could invoke this particular exclusion, that where the tax benefit is attributable to making of a choice election, blah, 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 then there is no tax benefit that arises. And suffice to say, in Nosa Holdings, it was unsuccessful. Nosa involved a whole series of very complicated transactions, licensing, sub-licensing of IP, payment of royalty, sort of assignment of the payment of royalty, and ultimately at issue was the deduction to Australian companies in respect of costs associated with their debt interests, the costs being dividends. And the taxpayer in respect of all bar 1 year was Nosa, which was the head company of a multiple entry consolidated group in Australia. And they did attempt to run the argument that Nosa's deduction was entirely attributable to the choice to consolidate, and in any other circumstances the deduction would have laid with AFC, another Australian sub. And the court just rejected it out of hand. They said the deduction wasn't allowed because of the election to consolidate. What actually happened was that the circumstances that permitted the deduction lay elsewhere. All that the election to consolidate did was moved the entitlement for the deduction up the chain. So it was an unsuccessful argument. Nosa, in fact, all of the first instance judgments that I'm discussing today, I think are subject to appeal before the full federal court. So this might be a watch this space. Now, just quickly, I'll talk about dominant purpose. This is another area where, when you go back to Hart's case, only one of the judgments, and that's the one of Gummow and Hain, talked about dominant purpose arising from a comparison between the scheme, what was done, and the alternative postulate. Prior to that time, I would suggest that the cases don't indicate that it would have been limited in that way to just the comparison, and it was more of a wider commercial inquiry about what was actually done. Since then, that judgment of Gummow and Hain seems to be the sort of orthodoxy. British American tobacco, which I talked about before, basically the court just said, look, the approach of a comparison between the scheme and the alternative postulate is actually required. That's the way in which you have to do things. And of course, in that instance, they found that the interposition of Rothmans in the sort of transaction structure was in fact motivated by dominant purpose to get the tax benefit of the rollover, which was kind of curious because there was plenty of discussion about the utilisation of the capital losses by the intervening entity, and that seems to have obscured some of the discussion a bit and have resulted in some arguments about whether or not it was a but-for test. When I read the case, had sort of wondered whether there had been some sensitivity about why the parties didn't argue that the dominant purpose wasn't the one that had been assessed, but was in fact the capital losses by reference to an entirely different entity, and assuming that the Commissioner hadn't assessed that entity and was out of time, you might have got up on your Part 4A case. In respect of Ashwick, Ashwick being, of course, the bad debt and the intra-group lending case involving the Fosters group, Justice Edmonds, he firstly more or less rejected the Commissioner's counterfactuals as not being sufficiently reliable, but nonetheless then embarked on a comparison for the purposes of ascertaining dominant purpose. And before he started to do that, he commented on the authority in British American Tobacco, saying this comparison is the way in which you must approach the identification of dominant purpose. And then he made reference to the extract from the judgment of Justices Gummow and Hayne in Hart, and said, well, that's the source of it. And then he made this reference: accepting for present purposes the correctness of what Justices Gummow and Hayne said in Hart, extracted above, it is difficult to discern its legislative foundation. It certainly does not appear as one of the matters enumerated in section 177D para B, being the 8 matters, relevant considerations. And as their Honour said in Hart, in response to a submission that the scheme had to be understood by reference to criteria outside the statute itself, namely that the term does not encompass the circumstances that are incapable of standing on their own, they said was this: there is no basis to be found in the words used in Part 4A for the introduction of some criterion additional to those identified in the Act itself. So that sounds like it might be a bit of an expression of discontent with the sort of prevailing view that it's a comparison between the scheme and an alternative postulate as to how the dominant purpose actually has to be ascertained. And I remember looking at this issue way back when Hart was first decided, and just in the immediate wake of Hart, the full federal court decision in Macquarie Finance, there was a similar sort of criticism made by Justice Healy, which seems to have disappeared in the mists of time, and this is back in 2005, and that's that the fallacy in this case is that, contrary to the direction in section 177D para B, it confines attention to the tax consequences of the actual and counterfactual transactions and leaves out account of the commercial advantages and consequences of what was actually done. So it does seem that there might be a little rumbling of discontent about this comparison approach, but in the end, in Ashwick, it was done by reference to comparison. And broadly speaking, the comparison resulted in the same conclusion that the dominant purpose wasn't tax avoidance, it was funding arrangements, ordinary funding arrangements within a corporate group. I've got my eye on the time, so I might actually skip over Nosa Holdings, except so far to say that Her Honour didn't confine herself to one alternative postulate, but looked at a whole series of alternative postulates and ultimately seemed to be very heavily influenced by the fact it was a change in corporate structure, and the Commissioner couldn't identify anything that would have resolved the difficulties that had caused that change in the corporate structure, and therefore there was no dominant purpose of tax avoidance in that case. In respect of News Holdings, this case is really principally relevant because it addresses one of the old issues about subjective purpose. Flip and spin transaction, lots and lots of steps in the flip and spin transaction, more or less to move the news group's holding company to the United States. And the Commissioner had taken issue with some of the steps during the spin, the sort of secondary aspect of the transaction, which involved an off-market buyback and capital reduction and the like. And instead the Commissioner said, well, why don't you just do that by reference to a direct transfer? And as part of the evidence, the taxpayers had led this evidence of their no tax risk policy to indicate that they wouldn't have done the transaction in some other way that was being proposed. And the Commissioner took objection to that on the basis that that was subjective evidence. And when you look at the judgment, the court held that it was admissible as objective evidence, and to the extent that that was closely corresponded to a subjective intention, well, that was a happy coincidence. So the court's judgment, it may be acknowledged that the difference between the actual purpose of a taxpayer on one hand and the purpose which is to be imputed to the taxpayer based on an exclusive set of criteria on the other hand is not without subtlety and has been misunderstood before. It is, however, hardly surprising if objective intention in fact accords with the person's subjective intention. If subjective intention is reflected in objective evidence, no error is made in taking that evidence into account, albeit that it is consistent with the person's subjective intention. So it's a fine line, but you can get some of this evidence in as part of the objective matrix of facts. But one of the things that I have noted both in the paper and just on that slide is that I wonder whether they would have been given the same latitude with the evidence that was initially admitted had they actually run the proceeding at first instance before the federal court. Notwithstanding the huge amounts of tax involved, this was run at first instance before the AAT, and in circumstances that their first right of appeal was to a full federal court forum. So possibly the slightly greater latitude with respect to evidence at the AAT might have motivated that particular decision in relation to forum. Trail Brothers also included a challenge to the validity of the Part 4A determination. It was unsuccessful. It seems that challenging the way in which the determination's been made in this case, because the amount of the tax benefit was wrong, the Commissioner had cancelled the entirety of the deduction rather than the difference between the deduction claimed and what would have been the deduction had they contributed to a superannuation fund. That wasn't something that invalidated the determination. And finally, I just wanted to quickly mention that Division 165 is the indirect tax anti-avoidance provision, and it's very closely modelled on Part 4A. We've got limited authority on it, 2 AAT decisions, and I think a federal court decision that didn't really engage with the issues because it was they were seeking to have it dismissed. There are, however, some indications that, notwithstanding that the AAT has had regard to the Part 4A cases, there are some differences. One is that a GST benefit can arise in respect of only part of a scheme. Second is that a GST benefit can arise even if there's no economically equivalent counterfactual, although query if you're comparing, if you get your GST benefit by reference to something that's not equivalent, how you're going to go with your dominant purpose or principal effect analysis on the basis that ultimately it doesn't achieve the same end. And the third is that there is a principal effect test about whether or not the main result of the transaction is the GST benefit for the avoider, no prejudice there in the legislation. And the final is that there are more factors to consider, including any other relevant circumstances. And I've heard it argued that any other relevant circumstances might extend to the guide to Division 165, which expressly mentions that it should only apply to artificial and contrived schemes. So that may be something that has a substantive difference. In any event, I think I've eaten into a lot of our question time, so I'll just finish there. Thank you.
I have one, Melanie.
Oh dear.
Trail Brothers.
Yes.
Trail Brothers was a case where there was a contract of service between a company and director. The company agreed to pay $400,000 into the superannuation of the director over 2 years. After the contract had been entered into, the legislation was amended that had the effect of meaning that the deduction that was available for the company for paying in the $400,000 contribution would cease to be available because of age-based limits, and that the maximum, I think, deduction available to the company would drop from $400,000 down to $39,000. So when that legislation was changed, the director and the company varied the contract so that it was agreed that the company should discharge its obligation to pay $400,000, not by paying to the superannuation fund, but by paying it into a discretionary trust. I always thought the scheme had been defined, at least when I was appearing, we defined the scheme as being, I acted for the Commissioner, as being the agreement to vary the contract so that the obligation to pay the $400,000 would be discharged not by paying to the superannuation fund, but by paying into the pension, into the discretionary trust. I thought that was a clear case of a tax benefit, because if that variation hadn't taken place, the payment would have been the contract to pay into the superannuation fund would have remained. The AAT disagreed and said, oh, could have done all sorts of things. The full court, where I didn't appear, said that the taxpayer had failed to discharge its onus of proving what would have happened if the variation hadn't taken place, but said that and therefore said that the tax benefit, the counterfactual, was to be regarded as being what would have happened if the contract had continued in existence, and had said, well, in those circumstances there would have been a deduction for $39,000, and the tax benefit was the difference between the $39,000 and the $400,000. In Lenzo, which had been decided some years before, Justice French at first instance, who's now the Chief Justice, had been met with evidence from the taxpayer that if the taxpayer had not entered into the scheme that he'd entered into, he would have spent the same amount of money on making a contribution to a superannuation fund, and would have got the same deduction that way as he got by entering into the Sandalwood scheme up in Kununurra that he did do. French said that that was not a relevant inquiry. He said that that deduction means that you look to see what the effect, what would have happened to the deduction you did get if you hadn't entered into the scheme. And so he said, well, in that case, in Lenzo, he wouldn't have got a deduction for $39,000 for having entered into a management fee agreement. And it was irrelevant that he may have used the money to get a deduction in some other transaction such as superannuation. The full court agreed with French to that extent. And I'm wondering, Melanie, whether the two full courts can be reconciled.
I actually don't think so. I know that the attempt is made by the court in AXA, but I actually do think that the two approaches are in conflict. And I remember reading Trail Brothers and just thinking, I don't understand how these two things can stand side by side. Yeah. But it does seem that Lenzo is now sort of, just a footnote, which has been conveniently forgotten without actually being expressly said that it's wrong.
Yeah, well, that's my view too. I think there's conflict between Lenzo and Trail Brothers. I'm not sure that it's a conflict with consequence, because there are funny things said by the present full court in AXA and Trail Brothers and Ashwick that all say that in determining the counterfactual, it has to be a relevant counterfactual. Yeah. And they say it's an objective test. So that seems to me to be two things. The court's saying it's going to determine what the relevant counterfactual is, and therefore it will come up with the right decision. So I'm not sure that what's the space, I think. I must say, otherwise, apart from that point, apart from that point, and I also, this integer point's got me tossed too, how you can say, well, the task for tax benefit is to work out what would have happened if you assume that what you did you hadn't done. So you take the whole scheme and then you assume it hadn't occurred, and then you've got to work out what would have occurred. In working out what would have occurred, you can actually accept that a number of the things you actually did happen, even though you're asked to assume they hadn't happened. Now, I don't mind that as a proposition, but let's take Trail Brothers, for example. There, they varied the contract. And effectively we said, well, the scheme was the variation of the contract. But the court said, no. The scheme that was articulated, this coming, I know somebody said the scheme's irrelevant. It actually may be irrelevant in a sense in working out the outcome, in the sense you can't say there wasn't a scheme, but it is terribly important in actually applying it. The court said the scheme wasn't varying the contract, the scheme was varying the contract to pay into discretionary trust A. All right, okay, fine. Well, if that's the case and you can take into integers, it's then open to a taxpayer to say, well, if I hadn't have done that, I would have varied the contract and paid in discretionary trust B. And if I hadn't done that, I would have varied the contract and paid in discretionary trust C. In each case, the relevant point for the taxpayer is to demonstrate he would have varied the contract. If he'd varied the contract, no tax benefit. I think this decision by the full court, contrary to the proposition we put in AXA, the decision in the full court that says you can take account some integers of the scheme really helps taxpayers. And it's actually the thing that was decided against the other way in Lenzo, because in Lenzo, as I said, the taxpayer had said, oh, well, if I hadn't paid money into a Sandalwood scheme, I would have put it into superannuation. What the taxpayer didn't say but should have said in Sandalwood was that in all these schemes, they're all geared up so that you're asked to put in $10,000, but of that $10,000 you can borrow $9,000 from the promoter. But you don't have to borrow the $9,000. It's that gearing up that's all done through round robins. And so, in fact, what everybody does is put $1,000 in and borrows the $9,000. But a common feature of all these schemes was that you don't have to do that. You can put in your own $10,000. And French decided at first instance that the investment in the Sandalwood scheme up in the Kununurra was so good that this guy would have put his own money into the scheme if he hadn't have geared it up. Unfortunately, he didn't say that in evidence. And when we went on appeal to the full court accepted that you can't take bits of the scheme and assume they didn't happen, and then in trying to work out the counterfactual, assume that they did happen. You've got to ignore the lot. But AXA and Trail Brothers now say that's wrong. It'll be interesting to see where all of that goes, I think. And I also think that the integer part of it is something that assists taxpayers. It's not something that helps the Commissioner. No more questions? No questions? All right. As I said, I think it's very, very interesting listening to people talk about cases that one's been in, and it's a shame that these two weren't there with me at the time when I was involved in them. It would have helped me, considerably. I mean, listening to Bill on the window tax, when I was a young lad, I came across my first examples of tax avoidance. I was travelling through Chester, and the window tax was imposed, of course, because the view was taken that if you had a window in your building, you were wealthy. So that's why they imposed the window tax. But if you go to Chester in England, it's full of these magnificent 16th century mansions. All the windows are bricked up. That was the first one of the first tax avoidance schemes to avoid the tax. Can we thank Bill and Melanie for their work?